25 years after the founding of our republic, a case before the Supreme Court, filled with legislative overreach and political intrigue, changed the course of American history. The cast of characters included three of our nation's founders and early presidents, John Adams, Thomas Jefferson, and James Madison, and a little-known Washington businessman named William Marbury.
Hi, I'm Doug Ginsburg, and I'm a federal judge. In the early years of the Republic, the role of the Supreme Court was evolving. In this case, Marbury versus Madison, the court for the first time asserted the power to decide whether a law passed by the Congress was constitutional. This process is called judicial review. John Adams, the vice president under George Washington, was elected president himself in 1796. Adams was a staunch Federalist, that is, a proponent of a strong federal government. In 1800, he lost his bid for a second term to Thomas Jefferson, who opposed having a strong federal government. Before Adams was to leave office in March 1801, the Congress passed the Judiciary Act of 1801, which created new federal courts and added federal judgeships. Adams quickly nominated, and the Senate confirmed, 16 new circuit judges and 42 new justices of the peace. These came to be called the Midnight Judges. One of those midnight judges, approved by the Senate under President Adams, was William Marbury of the District of Columbia, who had campaigned against Jefferson. But his commission was not delivered before Adams's term ended and Jefferson became president. So, Jefferson directed his newly appointed Secretary of State, James Madison, not to deliver Marbury's commission, the paper signed by Adams that made Marbury's appointment official. In the Judiciary Act of 1789, the Congress had given the Supreme Court the authority to issue a writ of mandamus, or an order compelling an official to do something. So, Marbury and other midnight judges petitioned the Supreme Court for a writ ordering Madison to deliver their commissions. There were three issues. First, do the plaintiffs have a right to receive their commissions? Second, if so, can they sue for their commissions in court? And third, does the Supreme Court have the authority to order the Secretary of State to deliver their commissions? This is where things get interesting and complicated. The court agreed with Marbury that 1, he was entitled to his commission, and 2, he could sue in court. But 3, the court held it did not have the authority to issue a writ of mandamus ordering Madison to hand it over. Chief Justice John Marshall, who had been appointed earlier by John Adams, reasoned that the Constitution is the supreme law of the land, and therefore any law that contradicts it is invalid. The court decided that the Judiciary Act of 1789, which gave the court the authority to issue a writ of mandamus, was unconstitutional. That provision of the Judiciary Act was null and void. Why? Because Article 3 of the Constitution grants the court very specific powers, and issuing a writ of mandamus was not one of them. After deliberating, the justices voted 4-0 that the court did not have this authority. Chief Justice John Marshall wrote the opinion, in which 3 other justices joined. 2 justices had recused themselves. And it was the first step in solidifying the judiciary's place in the system of checks and balances. Marbury versus Madison is so memorable because it's the first time the Supreme Court asserted the authority of judicial review, the authority to declare an act of Congress unconstitutional and void. It didn't actually do so in that case, but in the years since, it has declared an act of Congress unconstitutional in whole or in part more than 450 times, about twice a year over the course of our history.
Marbury versus Madison was decided in favor of Madison by a 4-0 unanimous vote in 1803. The key principle was Article 3, judicial review. The court established the principle of judicial review, empowering the Supreme Court to declare an act of the legislative or executive branch unconstitutional.